deadlines that apply to the River Park project. The Superior Court's decision to grant 11 months and 2 days of injunctive relief was both the necessary new material fact cited by the board to justify its rehearing of that 2024 extension request and the basis of its decision to approve a 1-year extension of all phases, restoring the originally agreed upon amounts of time for all phases of the project. A majority of the board perceived no case had been made by the applicant to support a 2-year extension. The condition of approval in the September 9, 2019 notice of action, which is the foundational agreement of record for the project, is that an updated phasing schedule shall be provided with any extension request. And while XYZ did not provide an updated phasing schedule in its most recent extension request, the board expedited its March 17, 2025 decision by making the subsequent submission of that schedule within 30 days a condition of approval. In doing so, the board relaxed a requirement of that 2019 governing agreement to the applicant's benefit. While notified of the board's decision in the customary fashion, XYZ did not provide the requested information, effectively voiding that 1-year extension that the board had approved. And additionally, XYZ did not file an appeal within the allowable 30-day period, which voided the opportunity to contest the board's decision on its merits. So consequently, for tonight, the first decision to be made by vote of the board is whether the applicant has offered a new material fact or change in circumstances to warrant a rehearing of the previously settled matter.
Oh, sure.
We are first determining whether we are holding a hearing by virtue of holding a limited public hearing to determine what new material fact or change in circumstance. And that is through an interaction with the applicant to learn more or ask questions in order to learn more about materials that the applicant has provided for our consideration.
You should be able to share.
To that end, and perhaps we should break for introductions because I kind of skipped over that part. It appears that we have Mr. David Clem representing Lime Properties and XYZ, and it looks like your attorney is with you this evening.
Yes, this is Robert Kaler. This is David Clem speaking.
The green light, David.
I'm sorry.
Thank you.
My name is David Clem. I'm the manager of XYZ Dairy. And speaking on behalf of XYZ Dairy tonight is attorney Robert Kaler.
Thank you.
I have a procedural question.
Oh, you're right there.
Is further consideration a thing?
Yeah, right
My introduction speaks to that distinction.
Okay, so the answer is no.
Correct.
there. Go down, you gotta reach under,
So this is a new application to look for a 2-year extension, and whether we hear it hinges on whether something new
Correct.
has changed. Okay.
Correct. Which is a beautiful segue into the first question that I have if we are ready to begin.
I just need 1 second.
I don't want to get ahead of myself.
So go to
Presentation.
slideshow.
Oh, great. Okay.
I will note, as just an attempt at a brief bit of levity, that it would appear that the applicant has well used his 30 days betwixt the last opportunity to be in front of the board and tonight. That was rather a significant package of information that you provided. It certainly captivated my attention for many of those days between meetings. But moving to the question that I have, for your new extension request, are you presenting as a new material fact that you've added tortious interference and civil conspiracy to the legal filing for the court's consideration in 2026? And in preparation for tonight's hearing, that you've presented a series of city staff emails and your interpretation of their intent as evidence to support those claims? Do we have an understanding of what it is that you're offering us?
Well, what's already been offered is the letter that Mr. Clem submitted. I propose to add some new information that justifies reviewing.
Press the button so the green light comes on your mic.
Oh, sorry.
Thank you.
I propose to present some new information that justifies reconsideration of it, and not proposing to go back through the letter or
Okay.
amendments, things. This is new information. And I want to start just discussing recent events since the submission that raise new issues.
Before we go there, if I may, I do have a couple of other framing questions to ask.
Could I make this presentation on the issue that you first raised first?
Okay.
Because this new information begins with the adjustment to the building permit, and the reason it's new information relevant to the request for extension is that XYZ needs the new extension to address something that's happened with the building permit. There are three things. This is the first one. The building permit, as the board knows, in 2019 contained a statement of structural special inspections, as they often do pursuant to the building code. This is from the 179-page building permit file of the city that's been produced to us. Building permits contain all kinds of information that's incorporated into the approvals. It contained a statement of special inspections and identified the geotechnical engineer of record as McPhail Associates. This was a condition of the issuance to have a geotechnical person because they have to look at various categories of aspects of the site, one of which was soils, and they had in the building permit, as required, the normal table from the International Building Code to verify excavations are extended to proper depth and have reached proper material. The proposed excavation had actually an application for the area, 220 feet by 165 by 15, which is the footprint of the new building. And Mr. Clem recalls that he would have wanted to apply for excavation separately, but he was told, no, put it in with the building permit. So it's part of the building permit. And it identifies the area to be disturbed. It identified by way of a drawing the outline of the building that was to be excavated. And construction work began on that in January. And as you can see, this is the drawing from the building permit that regulates excavation. And of course, excavation requires a permit separately. In this case, it was in with the building permit. And these are photographs of the commencement of construction in January and the outline of the foundation excavation. 40 years ago, I worked on an MBTA case in Porter Square. The man was killed in an open-cut excavation. He was buried just up to his waist. Excavation is part of construction, and it's a very dangerous part of construction, and it's a serious part. It was begun by XYZ in January, and the photographs prove it. The equipment's there, and the outline matches what the building permit had. So the excavation was stopped in January by a email to the contractors saying we need a $100,000 performance bond and temporary easement. XYZ's positions that's illegal. They can't do that, and it was never mentioned before, but all of this new information has just come to our attention in the last couple of weeks. And what also happened is that in early May, Mr. Clem wrote to the building inspector and said we recommenced construction at River Park earlier this year in January. Explained that he started excavation on the basement pursuant to specific references in the building permit authorizing that excavation. I've got skyscrapers settling in San Francisco because the excavations weren't done properly. It is part of construction of a building. The substrate supports it. The response was, this was only a couple of weeks ago, I disagree from the building inspector. I disagree with your statement that you commenced construction. And the argument was that the State Appeals Board had found that you need physical acts. Well, that's true. You need physical acts on the site. But then he claimed the activities in your letter are examples of preparatory work. They don't constitute work regulated by the building code. That's wrong. He went on to say your statement that Knott started excavation, he asked some questions about it, never came down to the site, and said, I can't reasonably consider this excavation to constitute starting work on the building permit, and I'm sure you'd agree that if you dug a foundation hole while lacking a permit, I wouldn't be able to cite you for working without a permit. He's wrong. New Hampshire law says you can't have an excavation without a permit. And this isn't digging a hole. This is not a game. This was an excavation with heavy equipment. There's references going back, commencement of construction in New Hampshire law includes excavation under the New Hampshire statutes. This is what has been XYZ dealing with in the last few weeks. We're going to deal with this. It'll be set aside. Either the court will set aside it on a contempt motion, or it'll be set aside administratively in an appeal. I'm trying to find a way out of this, I'm going to say at the end. But in any event, the issue here is that the building inspector at one point thought it was just, I got to check to see whether it's required by the building permit. The argument that you only need that digging a hole is not enough comes from a couple of years ago. There's Mr. Corwin and Mr. Reichert having an exchange about the building permit will expire and so on, but digging a hole isn't enough. Well, excavation with heavy equipment is not digging a hole. It's what you saw in the photographs. And back in 2023, it was either Mr. Corwin or Mr. Reichert noted in his draft of a letter that, can we provide a fuller explanation of why excavation work doesn't constitute work under the building code? I took a quick look at the copy of the IBC and couldn't find any because there isn't any. I've worked in construction cases for 40 years. Excavation is part of the work, but the difficulty is that the attempt to terminate this permit in this way, and they're not going to apply for a new one that has all kinds of implications. It isn't going to happen, but we are going to correct this, but it's going to take time, hence the need for the extension. And as a practical matter, it's also a continuation of what Mr. Clem claimed in his letter, but I'm trying to find a way out of this, and it starts here with an extension. Whether you folks realize it or not, I'm trying to help you. There's another major problem that requires the extension, and that is that the planning board has been acting as it should and must in a quasi-judicial capacity on these XYZ applications. But it's not acting impartially or independently due to its reliance on conflicted legal advice. It's required to be just as impartial as a court or jury, but the board has accepted and relied on legal advice provided by Drummond Woolson, that's Mr. Decker, and Christine Jones, which has been opposing XYZ in court. It would be as if any one of you sued me, had your own lawyer, and my lawyer was also the lawyer for the judge. It's a conflict, and it's been talked about for years in zoning manuals. This is just evidence from the city's recent production that Christine Fillmore is communicating and representing the city in connection with matters that related to an appeal, that Mr. Decker is providing advice to the board. He's counsel in the lawsuit between XYZ and the city that relates precisely to the same matters in front of this board. This isn't just a conflict, it's an obvious one. I'm not saying that you can never talk to city staff. There's lots of cases where there's nothing that's opposed, and I've been representing the MWRA, the Mass Turnpike Authority, the Convention Center. You know, there are informalities, but there comes a point where you start skating on thinner ice. It's like on Occam Pond, going too far.